All right, hello and welcome to this month's installment of Coffee with the Clinic. My name is Ashley and I'm an attorney in the Immigrant Survivor Justice program here at the clinic. Whether you're watching this video live or joining us after the fact, thanks for tuning in. Coffee with the Clinic is a monthly series that the Immigrant and Survivor Justice program started fairly recently, where we post 10 to 15-minute videos discussing various immigration or survivor justice related topics that we think may be relevant to the community. Today, we're going to be discussing non-immigrant status and more specifically, who you can include as a derivative on this type of application and what age out protections exist for those derivatives. As always, please note that this presentation is intended as a public legal education workshop for general information and should not be construed as specific legal advice. Immigration cases are fact specific and the law changes over time, as we'll learn in today's presentation. And because of that, we strongly recommend that you contact an attorney in your area to discuss the specific facts of your case. So before we jump into more of the specific material, for those of you that aren't familiar, non-immigrant status was created in 2000 with the passage of the Victims of Trafficking and Violence Protection Act. The immigration benefit was born out of concern that due to fear of being placed in removal proceedings, undocumented individuals may not be reporting crimes to the police or willing to assist in the ongoing investigation or prosecution of those crimes that they do report. So non-immigrant status, or the U visa as it's commonly referred to, was born and is an immigration benefit available for individuals who have been victims of certain crimes, have suffered substantial physical or mental abuse as a result of having been the victim of said crime, and are helpful to law enforcement in the investigation or prosecution of that crime. If the U visa application is ultimately approved, the recipient is given non-immigrant legal status for up to 4 years. That can be extended under certain circumstances, but generally 4 years, and that status can in turn be used as a pathway to citizenship. U visa applicants are able to petition for non-immigrant status not only for themselves, but also for certain qualifying family members, regardless of whether that family member was the victim of that initial crime. The U petitioner is referred to as the principal, and any family members that are added to their application are known as derivatives. In order to be included as a derivative on the U petition, the individual does not have to be in the US. They can still be living abroad, which is somewhat different than the rules that govern derivatives for asylum applications. Who can be added as a qualifying derivative depends on the age of the principal. If the principal is under the age of 21, they can add their spouse, children, parents, and unmarried siblings that are under the age of 18. If the principal is 21 years of age or older, they can petition on behalf of their spouse and their children. While that may seem straightforward enough, the Immigration and Nationality Act, which is the main source of law that governs immigration, has very specific and sometimes unique definitions of child, parent, sibling, as well as how you go about calculating an individual's age. So in the eyes of the INA, so the Immigration Nationality Act, a child is an individual who is unmarried and under 21 years of age. This includes children that are born outside of a marriage and stepchildren. In order for a stepchild to qualify as a derivative, the parent and step-parent must have been married before the child's 18th birthday. The INA's definition of child also includes adopted children, so long as the adoption occurred before the child turned 16. In order to be considered a spouse under immigration law, the marriage creating the spousal relationship must have been legally valid in the location where the marriage was performed. Previously, the law was such that the marriage needed to be in place at the time of the filing of the I-918, which is kind of the principal form in the U visa packet. However, the law has since changed where you can add a spouse after the initial filing. The key is that the marriage needs to be in place at the time the application is adjudicated. Finally, siblings are classified as those who were once children where the applicant and derivative share at least one parent in common. The definition also includes step siblings and adopted siblings, so long as those rules that we just discussed, meaning the stepchildren or the step parents were married before the child was 18, or the adopted sibling was adopted before they were 16. Immigration law loves to use abbreviations and speak in numbers. So of course you already know they had to find a way to do that with the derivatives. This slide shows you the classifications of each type of U visa applicant. A U1 refers to the principal petitioner. If they add their spouse, that person is classified as a U2, and so on down the list. Under the old U visa regulations, derivatives could only qualify for U non-immigrant status if the relationship continued throughout adjudication, so that status or age was maintained. Meaning you could have a scenario where a U3 derivative, so a child who must be unmarried and under 21 to meet that definition, was no longer 21 by the time the U visa application was actually approved, and so they just wouldn't qualify. This became an increasingly bigger problem as the delays in adjudicating petitions grew. People are currently waiting, 6, 7, 8 years for final adjudications on those applications. And obviously during that time, you age 6, 7, or 8 years. So legislation passed in 2013 and some subsequently after created what is referred to as age out protections for U non-immigrant derivatives. Specifically, they address circumstances where at the time of adjudication of the I-918, the U3 derivative was over 21, a U5 derivative was over 18, and a U principal was now 21, but had petitioned for parent or sibling derivatives. We kind of hinted at this on the last slide, but some of the specific changes that occurred as a result of the 2013 legislation was that principals who filed for their unmarried U3 children who were under 21 at the time of filing now continue to be classified as children, even if they are over 21 at the time of adjudication. A U1 principal who was under 21 at the time of filing and thus able to add more derivatives than someone who was 21 or who is 21 will retain that same age and status and ability to add derivatives. And age out protections were extended to siblings as well. So long as the sibling was under 18 at the time of filing of the I-918, they will qualify at the time of adjudication, even if they are over 18. Kind of more simply said, when a principal U visa petitioner properly files their application, the age of the qualifying family member or derivative is established upon the date of filing. This protection based on the date of, or the protection is based on the date of filing of the I-918 petition and not the I-918 petition for the derivative. So if you're familiar at all with the kind of package that gets submitted for a U visa application, the I-918 is specific to the principal, and an I-918 gets filed for any derivative that is wanting to be added to the application. So again, you go by the date that and the ages that existed at the time the I-918 petition was filed. To illustrate this point, here's an example. So Mary filed a U visa petition when she was 20 years old. 4 years later, while it was still pending, she decided to file an I-918 for her parents. Even though Mary is now 24, she can still file for her parents as derivatives because her age was established as 20 at the time she filed the U principal petition or I-918, and it does not go by her age when the I-918 is, or I-918A is filed. So when do the age out protections apply? Under current interpretation, the statutory language is being read quite strictly to require that the I-918 be pending in order for the age out protection to apply. This means that if an age out occurs, so a U3 turns 21, a U1 turns 21, or a U5 turns 18, when the I-918 is pending, they have complete age out protection. However, if the age out happens after the I-918 is approved, then the derivative is not protected and will go by their current age. You may have noticed that when we were going through the definitions of who qualifies as a child or a sibling, there was reference made to being unmarried. So you may be asking, do those protections, the age out protections, extend to if an individual gets married during the pendency of the application? And unfortunately, the answer is no. There are no protections for child derivatives getting married. Child derivatives must remain unmarried until the U visa process is complete and their application has been fully adjudicated. There are also no protections for siblings that get married. They must remain unmarried until the U visa process is complete. If they get married, they would automatically be removed from the application as they are no longer eligible. Interestingly, parents and siblings of principal applicants who are under 21 years of age at the time of filing will still qualify as derivatives, even if the principal applicant gets married. So in wrapping things up, I just want to highlight that age out protections become especially complicated when you're dealing with derivatives who live abroad and must consular process following approval of the U petition. This is one of those big scenarios where you might encounter an age out happening after the approval of the I-918 because there is a gap between the approval and the consular processing. So for reference, if you're unfamiliar, if a derivative is living abroad, kind of step one in getting them into the US is the approval of the full U visa application. But because they're living abroad, they need a visa to come into the US. So then they schedule an appointment with the local consulate, and then a U visa is actually physically placed in their passport, and then they're able to enter the country. And generally there is a pretty significant, or sometimes significant, time gap between that approval and when an appointment can be scheduled to get the visa and the passport. And so there are particular concerns to be aware of if someone is changing a relevant age between those time periods. So all that to say, if you have a derivative or are a derivative living abroad, please pay special attention to that issue. So that completes today's presentation on U non-immigrant status, derivatives, and age out protections. If you have any questions, please feel free to leave them in the comments, and a member of the clinic staff will do their best to reply. Again, thank you for tuning in and have a great rest of your day.